My name is not FDR of the state. It's a
We were there,
No.
sitting with whom?
Last circuit, your worship, Apraboto Chakraborty and Procedural Vishwas.
But that has to be corrected by them. We can't correct it.
There is a direction to pay compensation. We require what you have not heard in the case.
I do not know. Let us see the first day. Let us see how we can move. Just wait. Have patience. You have just heard. You have just heard. We are just arranging the things. Don't worry. Try to touch all the matters. Don't worry. Every matter will be touched. Don't worry. Why it is not included?
Order to raise the matter on the next circuit or first week of January, but from that date till date, the matter is not in the.
You know. Yes. Yes. Call the list.
Item number 1 and 2.
Why to be mentioned?
Actually, there was an order by the previous coordinate bench, my lord, that to report after every fortnight, report regarding the progress of the investigation. So this is the status report, my lord. My lord, we come to paragraph 14, page number 5.
এটা দিচ্ছি This special investigating team has been constituted.
My lord.
What is the progress?
Progress, sir, we have handed over the status report, madam.
This is
The
what
day-to-day,
you
the
have filed.
progress, madam.
What you have done with the investigating officer? The senior most police officer of the district, what he has taken steps against the investigating officer? Hey. The offense related to women.
I'm appearing on behalf of the applicant.
Wonderful. What kind of an agreement that is entered into by a Vyavsayi Samiti? What? I never heard about it. And your father was an employee, he used to run after that particular business. He was there as an employee. After the death, the relationship of employer and employee ceases. And then you wanted, secondly, you went there and filed a suit for declaration that you are a tenant under the plaintiff. Very interesting and very interesting. It was dismissed. The declaration was denied. Only injunction, obviously, because nobody who is found in possession can be thrown out without the process of law. The court has granted that injunction. Appeal failed. Second appeal dismissed. This order is staring at your face. If you are not a tenant, then what is your status there? Tell us. Because the agreement says that up to 1999, you were permitted to run. You are supposed to give an accounts and all everything. What remains? Tell me what is your right. Will it not operate as res judicata against you?
That will operate.
So what may? And the trial court confused with the word plaintiff. He did not realize that the plaintiff in that suit is actually a defendant here. He applied the principle of res judicata as if the plaintiff of both the suits are the same, which the appellate court has correctly overruled it.
Thank you for knowledge, my lord. I have just filed this application
For what?
on
Mercy.
on two grounds. Number one, that the exhibit number one, based on which the Garnet Additional District Judge has proceeded with the matter, is just an information which was sought from the RTI department and the state of information officer.
It's immaterial, sir. Forget about it. What is there? When we are in the second appeal, we can definitely go on the basis of the facts. This is the point which you tell me how you have to come out of it. Your client filed a suit for declaration that he is a tenant in respect of a suit premises and permanent injunction restraining the other side from evicting you without due process of law. Your suit was decreed in part. So far as the declaration of tenancy right is concerned, the court says that you are not a tenant. But since you are in possession, nobody can be evicted without due process of law. You challenged that in the first appeal. Did not get it. Second appeal was dismissed. So, finding as regards that you are not a tenant, that stands. Now, the plaintiff now filed a suit for recovery of possession, treating you as a licensee or as a whatever, the person having no title in support thereof. He has relied upon that judgment. Will it not operate as res judicata? I'm asking. Forget about exhibit 1, forget about exhibit 2, forget about everything. How can you wriggle out? What is your special status? Can you raise this plea of tenancy again? Then what remains? You are a person without any title.
I am a trespasser.
Trespasser, licensee, or permissive occupant, whatever. But not a tenant.
Not a. What? But, my lord, the learned court below has made this judgment on the basis of three exhibits. Exhibit 1, which is not an information, which is not any document which has been provided by the state information officer, my lord. It's just an information which has been.
Forget about it. Suppose we discard this exhibit 1.
My lord, in that event,
Then what happens? Then how it will improve
then
your
let us
case?
see whether the plaintiff in the present suit is the actual owner of the property.
Is it necessary? If he has a better title, can he not?
Has
And
been-
secondly, sir,
Can you challenge
I am
the title?
actor. Secondly, sir, in your suit, you claim tenancy under him.
in the previous.
Can you now deny that he has no title?
But my lord, he has failed to prove his title over the.
Is it
property.
necessary, sir? I am asking you in a suit.
No, as because still in the
ও
presence.
নিজের টেনেন্ট ক্লেম করলো প্লেন্টিফের আন্ডারে এখন এসে কিভাবে বলবে যে প্লেন্টিফ ডাজ নট হ্যাভ old section 116 stares at your face.
But
New BSA, I do not, I mean, the
Evidence.
Bharatiya Sakya Adhiniyam, BSA. What is that section? I don't know. 116 is the old Indian Evidence Act. That is staring at, can you deny the title? So,
But in this presence, my lord, he has failed to show any document to the extent that he has been granted by the website committee that particular.
who is the website Samiti? This particular stall was allotted to him. He was running a business. Your father was
But that.
in, your father was introduced in the stall by him.
But whether the stall was allotted to him.
Is it a material question? I am asking you. If a person has put you in possession, that is an admitted position. Then whether that person has to prove his title, he has proved that he had a possession, maybe without support of title. But 116 has toppled against you. You can't say he didn't have the title in the property. What remained?
My lord, what thing is in regard to exhibit 3. The agreement, my lord. The person who has.
That was website Samiti agreement. Up to 1999, you were permitted to run in that arrangement that you are being an employee. That's all.
And that agreement which was proved in front of the court was not by the custodian of the agreement.
Have you challenged that at the time of marking this as an exhibit?
My lord, it has been as objected to.
Objected to. Did you raise that point before the trial court at the time of hearing?
My lord, in cross-examination, it has.
It is not. I am talking about 2002 volume 2 SSC against you. Justice S.B. Sinha has said that if the document which is at the time of marking an exhibit has not been objected to.
It has been objected.
Correct. I'm coming. Happy. Not objected to. Then it cannot be objected at a later stage of the proceeding. Second, Justice K.T. Thomas judgment is there, 2001, page 1, volume I always forget, I think volume 1 or 2. It says that if a document is marked as an exhibit after an objection, then at the time of hearing, the objection has to be raised. If it is not raised, then it will be deemed that this document is admitted. I do not find from the trial court judgment any objection on that behalf was ever raised. Secondly, there are distinction between a mode of proof and a document which is inherently inadmissible in evidence. You are talking about mode of proof, which cannot be challenged at the latter stage of the proceedings. Inherently, you can.
My lord, my limited, what I have wanted to give, my lord. In the trial, my lord, this document was challenged. This document was stated that this has not been properly proved as well as in before the additional district judge.
That is what I'm saying. It is not there. It is not there. And again, I'm saying, suppose if we forget everything. Now, after that judgment in the first suit, why you went to file a suit? What prompted you to file a suit? Res judicata is staring at your face, sir.
122, sir.
It is now 120. Same. It says no tenant of a immutable property or a person claiming through such tenant shall during the continuance of the tenancy or any time thereof be permitted to deny that the landlord or such tenant had at the beginning of the tenancy a title to such immutable property. You are talking about that. You can't. There's a stopper. Anyhow, sometimes bad cases are to be set at rest. Yes. The plaintiff respondent filed a suit for recovery of possession against the defendant appellant on the premise that he was put in possession as a permissive occupant / licensee and does not have any title. of a tenant, a title as of a tenant or otherwise in respect of. The trial court dismissed the said suit, applying the principles which are contrary to law as well as on fact. Full stop. The appellate court reversed the said judgment and decree, which is now assailed in the second appeal. It was a specific case of the plaintiff respondent that the father of the present appellant was an employee under him to run his business at this stall, being the subject matter of the suit property. This is the subject matter of the suit. The said father died on 17/12/1996. But the appellants, being the heirs and legal representatives of the said employer, refused to hand over the keys of the said stall. So it is further averred in the plaint that such dispute was referred to a Siliguri Vidhan Market Babsai Samiti, and a consensus was arrived in a meeting dated 26/6/1997 that the appellant may be permitted to run the business in a similar manner that of his father till 31st December 1999. I have read it, don't worry. Stop. After the expiration of the period, the position remained and continued. And in order to protect the same, the appellants approached the civil court by filing a title suit number 108 of 2000, seeking declaration 2000, seeking declaration that he is a tenant in respect of a said stall under the plaintiff respondent, and permanent injunction restraining him from evicting and or dispossessing the appellant herein without due process of law. The said suit was contested by the plaintiff respondent, ultimately culminated into a final decree, by which the decree for declaration was negated by the trial court. But since the defendant appellant was found to be in possession of the said suit property, permanent injunction was granted, restraining the plaintiff respondent from dispossessing and or removing him from possession without due process of law. The decree of the trial court was challenged before the first appellate court. But the appeal was dismissed. So also the second appeal by the High Court. Such being the fact, next paragraph, such being the fact discerned from the record, the only point which involves in the instant appeal is whether the judgment and decree passed in title suit number 108 of 2000 would operate as res judicata against the present appellant. The counsel for the appellant sought to contend that Exhibit 1 and Exhibit 3, which were which were received in evidence after objection, have not been proved in accordance with the provision of the Indian Evidence Act. It is sought to be contended that Exhibit 1 did not come from the proper custody, and the author of the said document was not examined by the plaintiff respondent. It is further sought to be contended that the agreement which was entered into at the intervention of the said Samiti, Babsai Samiti, would reveal otherwise, and in fact creates a right into the appellate. So we are unable to appreciate the contention raised by the counsel for the appellant in this regard. Stop. Even if we accept the contention that the aforesaid documents were not properly marked as an exhibit, yet it does not dispense with the nuances of law, more particularly the principle of res judicata having applied in the instant case. The appellant approached the civil court seeking decree for declaration of his tenancy right in respect of a suit property, which was negative by the trial court, and such decree is affirmed up to the second appellate stage. The principle of res judicata is based upon the public policy, as every litigation in this country is to attain finality and should not be permitted to be redetermined or re-adjudicated at a subsequent stage. The doctrine of res judicata has a sound principles and received recognition in the statutory form by introduction in section 11 of the Codes of Procedural. The moment the issue, which was directly and substantially an issue in the earlier suit, has been decided finally, such issue cannot be reopened nor be permitted to be re-agitated in the subsequent proceedings. The issue relating to declaration of tenancy right received quietus the moment the suit filed by the appellant was decided against him, and therefore cannot be reopened in nor can be resuscitated in a subsequent proceeding. The moment the right as a tenant is decided against the appellant, the status becomes precarious, and the person having a better title is entitled to seek a recovery of possession from a person having no title to it. Next one. A plea is sought to be taken that the plaintiff respondent has miserably failed to prove his title in respect of a subject property, and therefore the appellate court was not justified in reversing the decree of the trial court. We are not impressed with the aforesaid submissions for the simple reason that the father of the appellant was put into the said suit property as an employee to run the business of the plaintiff respondent. And therefore, the moment the position is transferred, which is one of the incidents of putting a person into a position, putting a person in the property, his stopped from challenging he's stopped from he's stopped from contending that the person who put him in position had no title in respect thereof. From whatever angle we look at, do not find any involvement of a substantial question of law. Accordingly, the appeal is dismissed under Order 41, Rule 11 of the court. Yes. Let's call the next. ওটা কেসটা শুরু হয়েছে বিএসএর আগে। Why it has already been admitted, then why it is coming under Order 41? এরা কি করে এরা এইভাবে?
Item 4, item 4.
No, this is FMAT 12. FMAT 12. FMAT is admitted. Then how under Order 41 Rule 11?
Already admitted.
It appears that the instant appeal has already been admitted on 3/2/2023 and therefore is wrongly listed under the heading Order 41 Rule 11 of the court. Let the application being Can 1 of 2022 be listed day after tomorrow under the heading application.
My lord, if I may mention, my lord, my lord senior, an unfortunate event happened last night. His mother passed away, Mr. Nabamkur Pal. So if my lord can keep the matter in the next circuit, it would, I would humbly request for that, my lord. Since he's not allowed to come out of the house for another 14 days.
With the admission being can one listed there.
ওটা কেটে দাও। In such view of the matter, the application is required to be the application is required to be listed. Stop. What is your good name?
Bodhisattva Ghosh. Bodhisattva Ghosh.
Mr. Bodhisattva Ghosh appears and submits that the advocate on record. Who is the advocate on record?
Nabamkur Pal.
Is the advocate on record?
No, my lord. No, my lord, I need to.
No, Mr. What is his good name?
Nabamkur Pal. Nabamkur Pal, my lord.
Nabamkur Pal appears for the appellant in the instant matter and lost his mother last night. And because of the bereavement, he is unable to appear in this circuit. He thus prays for an accommodation in this regard. So, in view of the above, let the application be listed in the next before the next circuit bench. Let's call the name.
Lordship, in item number 5, Doctor.
Section 5 is there. It has to be heard by a single bench. Why you are listing it?
Lordship,
That's
Doctor.
all. It appears that the instant application is the instant appeal is filed beyond the period of limitation provided therefore without therefore application is filed, I believe. Therefore, full stop. An application being Can 1 of 2023 is filed for condonation of the delay in preferring the instant appeal, which is required to be heard by the single bench before the matter could be listed under Order 41 Rule 11 of the court for admission. Hence, let this matter go out of list. Liberty is granted to the parties to mention the matter before the single bench. Call the next.
My lord, I'm for the appellant. My lord, praying for next circuit.
Nothing, no, next circuit.
The constitution. You must have next stage. Section 5 of the report. Yeah. Section 5 of this. Analyze as far as judgment the approach is the discussion of the first appeal. Second appeal. And the two reason value. Because merited over a decide of chip and value. So, without editing, so that we can dispose of such a thing from here. So, that could be
After perusal of the impugned judgment and order, we feel that the matter can be conveniently decided at the stage of an admission, provided a notice is given to the respondents. So accordingly, the appellant is directed to serve the copy of the memorandum of appeal as well as an application filed in connection with the instant appeal, a connection therewith upon the respondents by speed post, as well as upon the learned advocate. Is there any execution pending?
My lord, I'm not well versed with the matter, my lord.
Is a partition decree, final decree, which is under challenge.
Yes, my lord.
So there must be something there.
Yes,
Execution stage must be there.
but I'm not really well versed with the matter.
As well as upon the learned advocate representing the respondents in the executing court, indicating that this matter would be listed on 12th. I think by this time
Yes,
all the rituals would be
might
over.
completed.
still any.
Number 7.
ও আমি জানতাম সেজন্য আমার লেখা হলো none appears, nobody appears, nobody does. মানে একটা order, just you go through order. None appears. None appears.
হ্যাঁ, নিজের কোর্টে আটকে রেখে দিই।
First day, should I dismiss? Because he is not appearing since last 5 days. None appears, the order is passed.
দুদিনের সময়
Puridi, let him come, we'll restore it. Dismiss. None appears, dismiss for default. Dekhi কি আছে? Anybody knows him? Dekhi একবার fight. Anybody knows Mr. Orupratan Chaudhary, heir of Tapas Kumar Bhattacharya? What is doing? Since last, I think 2020, September 2024, there is no appearance. Even before us, there was no appearance. So we are dismissing it. If he is interested, let him file the application for restoration. See to. Call the next.
Number 8.
Same.
8 my lord, I appear for the courts. My lord, I've been recently briefed. Kindly takes it up next week. So there's a change of briefing.
That is what you have chosen a wrong judge.
No, my lord, I've been briefed today.
I have a greatest of reservation when the council appears and says, I have received a change brief. I am not ready.
My lord, I've received today. Kindly.
That's
give
why
me
I'm
2 days.
saying you have chosen a wrong person.
Not on Wednesday. I'm not praying for next week.
What?
Lord, kindly consider. I've just received it today.
So you Whether fraternity or mental major.
Lordship,
Just 1 minute.
Lordship, in this matter, Mr. Mominur Rahman is appearing, Lordship, and his mother is dead, Lordship, a few days ago. That's why he could not come, Lordship.
Who is the advocate and the court?
I am that one.
So why don't you do it?
Lordship, actually, chamber is closed, Lordship,
What? Chamber is closed?
because Lordship, senior's mother is
So what? You have a brief of yours.
brief with in chamber, Lordship.
You don't carry a brief in your chamber.
I don't have a chamber, Lordship. Lordship, Wednesday, Lordship, he will come Wednesday, Lordship.
The appeal shall be heard on the following substantial question of law. 1. Whether what the courts below were justified in dismissing the suit solely on the ground that the plaintiff has miserably failed to satisfy the court that the challenge to a decree was made within the period of limitation, though the limitation runs from the date of the knowledge. Next paragraph. Whether the plaintiff is precluded from challenging the deed executed by his brother during his minority without indicating the legal necessity or obtaining the permission from the competent court. Requisites do one thing. Service of application করে দাও. Oh, no application is filed.
No, Lordship, application has been filed, condemnation of delay
Can one.
delay has been
condoned.
condoned, Lordship.
So I know, that's why I'm saying. So there is no other application filed. No injunction, nothing.
No. No, Lordship.
Requisites karo. The appellant is directed to put in requisites within a week from date for effecting service of notice of appeal upon the respondents. So, upon the filing of the requisites, the office is directed to effect the service upon the respondents immediately. In addition to the same, the appellant shall put in the Kalwana for effecting the service as indicated above within 1 week from today. Let the trial court record put on section 5 she wrote and condone let the trial court record be called for Is there concept of special messenger here?
Yes, yes, Mr.
Call for at the, through special messenger at the cost of the appellant. Such cost shall be put it within a week from here. After the arrival of the trial court record, the official examine the same, comma, if found complete, comma, shall issue a notice under Rule 12 of Chapter 9 of the Appellate Side Rules upon the advocate and record of the appellant. Next paragraph. The appellant is directed to prepare 8 copies of informal paper book, Xerox, saccharosite, printed jars, within 4 weeks from date. After the service is effected upon the respondents and the paper book is filed within the time indicated herein above, liberty is granted to the parties to pray for inclusion of the appeal for final discussion.
First, give me liberty to file the stay application.
Liberty is given. Liberty for a statutory right. This is up to you. And you are asking for time.
You must get food.
If I get such opportunity, my lord.
Yes.
But here, my lord, this is a judgment of affirmation. My lord,
Yes.
Father is a Sambuna. Sambuna drag on because of taking the wife, son, that who is a plaintiff. The group is knowing of our court is over advance. Partisan by a deed of the project. I think that what to me would find it a challenge.
it is a judgment of. You say
Your
ready.
father,
Ready.
father Shambhunath and your uncle Noni
No,
Gopal,
we are
they
there.
purchased the property.
I'm not going to this question.
Will not go to the question.
I just want
Your father was inducted in
I'm
respect
coming.
of a suit
What's the-
says at a
Yes, you lost it ready,
maximum
right?
rupees 60.
You was ready. I'm not my question. Question is, my lord, my point is that whether the spouse is a necessary party.
2G, I have saying 5 years has already elapsed.
No.
Now,
Yes.
now
Yes, you
question is-
my lord,
question-
I
I understand where you are heading. Now, this 5 years is not, the 5 years is
also
not
to be decided.
not a simpliciter. 5 years is not, there must be certain.
I just,
conditions
what I'm trying to, so you lost, I get the loss. First, my lord, this latter part, non-residential, non-residential purpose. Spouse are there. My point, first point is that, my lord, whether spouse is a necessary party for filing of the eviction, assume that after experience of 5 years. This is my point. This is my basic point.
Let the spouse take appropriate
Well,
steps.
he's not necessary party. That is his duty. This is not section 6, my lord. You see, on the expiry of 5 years, the landlord has a right to file a suit for eviction. So he has a right.
Here, your father died
In 2009.
In 2009.
Yes.
After 2002.
And I just come into force. I'm not. Well, 2G's latter second part, spouse is there. So now, my second point, I just subject logical.
Simple spouse will not do. There is a condition which is attached. Please look at the definition of the tenant under section 2G. Read the definition.
But I am also.
Please read, provided
It's a residence
is dependent upon. It says it will apply mutatis mutandis
Yes.
to a non.
This is my lord. This is Costa Summit. This is my lord. I am.
Casus omniscius.
Yes, this is a judgment of the division bench, Supreme Court.
Casus omniscius.
I'm showing my lord. I'm showing my lord. But you also can. This I got the opportunity. So my lord. But you also first. What I'm trying to submit again, I repeat it. My lord, I'm not going to second proviso, first proviso. I'm coming there. In the section itself, 2G, they say, assuming that is also my one more point. I subject loss of correction. I place it. That has not been directly decided. I'm coming to this point. After my point is that in respect of letting out the non-residential premises,
In
after
respect of letting out.
non-residential premises. This is type, non-residential premises. That suppose 5 years time period is applicable for cessation of the tenancy. If the landlord has the right to file a suit for eviction, spouse is a necessity or not? You should say me that first question is regarding residential. Second preference, giving the preference to the son and sons, and that is applicable more than this. Supreme Court says, and our division bench also says that there is some word has been missed. I just placing. So, I am not going to provide so. Section itself says.
You're talking about Justice Sanjeev Banerjee's judgment.
Judgment, and then my Supreme Justice Chandra.
I understand.
I know you. But this is the my point is that I'm not going to first and second twice. In the section itself, it is not. If that notice is there, then
No notice.
no, I know.
What are
But sections no. Section 6
No,
not.
let her speak. What are it is? Why for preventing her?
No, sorry. But notice in section 6. No. So section 6 is not. It's a that it's not a section 6. So no notice. See, it is automatic.
With the notice.
It's so. So my lord, then at the same time, what I'm trying to, if it's a notice, then my lord, mother can come, spouse can come separately.
Sir,
Here, my lord, what I filed.
Okay, sir, you said that after the death of my father, the rent was collected from me. I have paid.
Any event.
I have paid the rent.
Yes.
Actually, I was.
No.
taken
My.
So where the concept of the spouse, your mother comes.
But it was a
You have set up an independent.
But appellate court has not decided it. Appellate court has not decided it. Appellate court.
Independently.
No, that has been accepted. But you also can see.
That was not accepted.
Accepted. But can you see the order judgment of the appellate first?
He says that does not create any independent right of tenancy in me.
No, I said my father was running the business there. I also helped them. I was, it is in my position. But my Yosemite appreciate section 2G letter part is very clear, even in respect of the non-residential purposes. Spouse, son, daughters are there. So spouse, 5 years is applicable.
It simply says that the provision relating to a residential would apply immediately.
No, this is provide, no. I'm not,
Then the right of preference. Then the right of preference is there.
I'm
If
not
the
going to
landlord
preference.
wants to relate, then you have a right of preference.
No, I'm not going to that, my lord. You can't you see?
Read the section first.
Yes.
Unnecessarily don't exhaust your energy in this regard. Read section 2.
I'm
Please read.
No.
Investment of presidency.
Excuse me, I have. My lord, I just. Section 2G.
Please read.
Yes, please. Tenant means any person by whom on whose account on behalf rent of any premises or is or bought for a special contract would be able and includes any person continuing in possession after termination of his tenancy and in the event of death of any tenant. Also includes for a period not exceeding 5 years from the death of such tenant or from the date of coming into force of this act, whichever is later. His spouse, son, daughter, parent, and the widow of his PTC son, who are ordinarily living with the tenant.
Now, this is what I say, it's not a simpliciter.
No,
That's
this is
the
not applicable
conditions
to me.
I'm kidding. Are living, read that.
I'm going to type to some.
5 years is not absolute.
No, not for
You are living.
Yes, I'm coming.
Yes,
I'm
you are
coming.
living.
Tenant up to the date of death of tenant and the dependent on him and do not own occupy the any.
True.
Sorry. Coming to force of this act, which later his spouse, son, daughter, parent, or the widow of his PTC son, who are ordinarily living with the tenant. Yes,
One condition.
Yes. This condition.
Then it's conjunctive.
Yes,
Read.
I'm coming. Tenant up to the
Date of the death.
death of the tenant as a member of his family and
This is second as a member of the family. Then
one is
he was residing with him at the time of his death.
Dependent.
Second is a member of the family. And third,
who are down who do not own or occupy.
No, he is as a member dependent and who does not own an independent house.
But this is regarding, and what, this is regarding residential.
Residential.
Now I'm.
Now you consider.
Now, and
Please.
when there's a comma, then I also argue on this point, your lost kind. In respect of premises,
Correct.
let out for non-residential purpose, his spouse,
His spouse,
son,
son,
daughter, and parent, it is his son, those who are already living with the tenant. Where is living, my lord? Not in the non-residential.
ordinarily living with the
The-
tenant.
Yes, then
Please, then.
living with the tenant after date of his death as a member of his family and or dependent on him, or for a person authorized the tenant who, I'm not coming this, position of such premises, but shall not include any person against whom the decree or order for eviction has been made by a court of competent jurisdiction.
Correct.
Next one, first proviso, and what I'm trying to,
Please read.
provided that the time limit of the 5 years shall not apply to the spouse of the tenant who are ordinarily living with the tenant after his death as a member of his family and are dependent on his hand, who does not own, occupy, and residence premises. So spouse has given a benefit.
Then next.
Then second proviso, provided further that a son, spouse has been excluded, daughter, parent, or the widow of the predeceased son, or the tenant who was originally reside with the tenant, the said premises, up to the date of the tenant as a member of his family and was dependent on him and who does not own or occupy any residential premises, shall have a right of preference for tenancy in a fresh agreement in respect of such premises on condition of payment of the fair rent. These provisions shall apply mutatis mutandis to premises laid out for of a non-residential purpose.
Now
Now,
you wanted to say that this mutatis mutandis is applicable only in relation to a preference, not in relation to any other things. But in a enabling provisions, which is there, it says the spouse is also included within a purview of this non-residential tenancy.
Yes,
I got
yes.
your point.
this point, secondly, my lord, court says, since my son is doing the business, Apple is doing the business, so mother has been excluded. Question is, my lord, deciding not, what is the legislative object is that deciding not in a non-residential, deciding in a separate house. This is for the non-residential purpose.
No, the question is that a person lives in a residential house, but a person who earns his livelihood from a different house. The question was that a person or a spouse is not expected to be a very active partner or
Yes.
an active participant in the business purpose. So that is why the legislatures were there, that if the spouse was living along with the tenant,
Yes.
who was doing a business,
Why is
was
the deciding, my lord?
dependent and was totally dependent upon him at the time of his death, then in that event, these conditions have to be fulfilled.
What I'm trying to
But
submit,
the
my lord.
question is the mere, sometimes it so happens
No,
in a
that is,
scenario,
my lord,
you
that
do
is
not know,
what.
it is up to you who have to prove. Only
My lord, by the
you have to
subject
prove
of Sky, my lord,
that you were dependent upon the.
my lord, this point has not come. This is on the question. This can you see, but that point has been dealt with. It was kindly.
It's a pure question of law
My-
based
my
on
po-
the admitted facts or the.
No, they say
Facts
that
which are there on record.
civil judge junior division says she is not the necessary party because the petitioner, the applicant son was running the business with the.
That is what your case was, that after the death of my
Yes,
father,
but
I was issued a rent receipt and the landlord collected the rent receipt,
yes.
issued it in my name.
Your
So,
question is correct.
so this
No, man,
concept of
I-
2G
I-
has
but I-
gone.
I-
Now I have become a new tenant.
That has not been accepted. Then I alternative case.
That has gone.
My case is that
Well, where
spouse.
is your written statement?
Yes, I show. I know you have to.
Where is your written
My
statement?
case is application was state.
Have you annexed the written statement?
Yes. That's them. What?
Stay application?
It starts from page 22.
Stay application টা কোথায় আছে?
State of the
নেই।
কে আছে তো? ঠিক আছে।
Stay application টা কোথায় আছে? When you file, but it is not included.
No, that they,
Bring it from the department. Just, it is listed. Can one? No, there is nothing. TIS record does not indicate that you are filed.
the long days back, my lord.
Where is the receipt? Downloaded information that can one is filed.
April is now. I said, "Man, this is.
Even a list does not show there is an application.
That, but there she has filed. Maybe even.
Where is the show us the Canva? From where she got Canva? From the website, it has to be there.
No,
Chago
April
to
like-
ek department de padao, let it come. It's Passover for the time being. We are taking up another matter. Let us see. It বইটা একটু ফেরত দিয়ে দাও তারপর পরে নেব
মানে এইসব বইগুলো আনিয়ে রাখবে
হ্যাঁ বই আছে হ্যাঁ খাবারটাও বার করে রেখে দাও। ঠিক আছে ওকে give it to them no cap
Hey,
he has record says no cap
No, my lord, she has filed. I go to
It's
the
not.
department,
they have taken out
I go to the department and see, my lord, your son.
এটা ডিপার্টমেন্টে জিজ্ঞেস করো
My lord, can you, your
Fine.
son at the 2 p.m. Yeah, I personally send them, department. I can you take it 2 p.m. then,
no you come after 15-20 minutes
yes, I'm here.
call the next ডিপার্টমেন্ট একই 11
Lordship, I picked up your petition.
ওটাকে আপলোড করেন yes call
Lordship, this is a matter arising out of an Act 8 case.
just one it appears that the appeal has already been admitted on 5/11/2024 and therefore wrongly appearing under the heading Order 41 Rule 11 of the Procedural Procedure for admission. Let the application be listed day after tomorrow. Oh, where is the application? You have not filed application.
No, Lordship, I have filed. The paper
Where
has
is
already.
the
been-
application? I do not find any application.
Lordship, the application has been filed and it has also been
No,
admitted,
no.
Lordship. It has been admitted by the bench of.
I have seen, that is what I am saying, why it
Alright.
is appearing under Order 41 Rule 11. Now, application get it up. It appears that the paper book has already been filed. So, let the same be tagged with the instant record. Achhe, okay. So, in view of the above, let this matter be listed
Day
day after tomorrow. for
As your
final
Lordship pleases.
disposal.
Grateful, Lordship.
Next. Yes.
Lordship, in item number 12, Dr. Arjun Chaudhary. Kindly keep it Thursday, Lordship.
Let us see. None appears. Section 5 allows.
This is something we could not do, but in your favor, this is, there is no opportunity but to set aside the party declaring the title over the property. However, the decree dismissing the prayer for such and such is hereby. Commander can set aside coach. The appeal is hereby dismissed.
জানাও করা উচিত। হ্যাঁ, পারলেই তো
টাইটেলটা ডিক্লেয়ার করলো না। না, টাইটেল যেটা ট্রায়াল কোর্ট কি করেছিল, টাইটেলটা ডিক্লেয়ার করেছে আর রিকভারিটা টাইম। সেখানে বললো যে টাইটেলটা আমি স্যাটিসফাইড করে দিলাম, ভুল করে করেছে ডিক্লেয়ার। আর অ্যাফার্ম দিয়ে ও যেটা বলেছে যে রিকভারি হবে না, কেন যখন টাইটেল চলে গেল তখন তো রিকভারি হবে না, ঠিকই বলেছে। তারপর এখানে অ্যাপিল ইজ ডিসমিস, ইট ইজ টু বি অ্যালাউড। তারপর এখানে করে দিয়েছে পার্ট অফ দ্য জাজমেন্ট ডিক্লেয়ারিং দ্য রাইট over the scheduled property is hereby satisfied. The part of the judgment dismissing the prayer for such and such is hereby affirmed. Ultimately, such and such is hereby dismissed. Did you ask for a correction?
No, Lordship.
There is a defect in the appellate judgment.
Lordship, for admission of the second appeal, Lordship.
Ma'am, have you checked that there is a very serious discrepancy in the judgment?
Lordship, kindly keep it on Thursday, Lordship.
Keep it on Thursday.
Lordship, he will appear and move the matter, Lordship. Kindly keep it on Thursday. Due to some personal difficulties, he is out of station, Lordship.
The ground of ambiguity, যেটা আছে, ওটা তো can be a ground for dismissing the sort of execution এ হবে, whether it is হবে কি হবে না, which is a different point. We can amend that. Is a case for admission.
Kindly keep it on Thursday.
We are going to admit it.
Lordship.
Adjourn.
Lordship. Lordship, small indulgence, Lordship. In item number 5, Lordship passed an order that confirmation of delay is pending, Lordship. It already condoned, Lordship. It already condoned, Lordship.
No, it does not appear.
Yes, Lordship. The order sheet is there, Lordship.
We'll see to it, whatever. Any on next? 13. On the 13th?
Yes, I am. Lordship, text of the stay application, the impugned order is on page number 96.
Also annexed with a memo.
Yes.
Don't forget. Have you served the copy?
Yes, I have already served them, then it was taken up for the earlier bench.
No, it was fresh notice was directed. Where is the affidavit of service?
He's a corner. He says that one of the corner indicate the development agreement execute for any upon depriving me to injunction. Injunction was granted on January 2025 by this court. That also secure for the
In the trial court, have they appeared?
Two of them have, out of 7, 2 of them have appeared.
Can you serve a notice upon them? The developer has been served.
I shall,
Because this is what you say, item delivered, I find from the track report. But whether the developer has been served.
I shall take instructions. Okay, I will do something now. But
Day after tomorrow, we are keeping this matter.
Lordship,
You consider this. Not
Yes.
today, not today and tomorrow. Not today and tomorrow. For the next matter.
14 Millard, I represent Millard the appellant. The second appeal for admission. But initially Millard.
Just 1 minute.
Yes, I'm sorry.
Why you want to eat up? Birth certificate of the daughter was produced.
Millard,
It was produced
Millard,
and
no.
it shows the name of the father.
Yes, that's right.
So that in that event, suppose you dispute that she is not a legally wedded wife,
Millard, that's not the real
but the
dispute.
daughter is entitled to all the benefits of the father.
Millard, that's not the real dispute, Millard. Millard, the case.
Real
was-
dispute is that the gentleman who was in the tea garden, he died.
He died.
Then this
Bloody-
lady with the daughter came forward. You being the sister-in-law means the wife of the elder brother
Elder
of the
brother.
deceased.
Yes.
You claim the employment on the ground of this. May
Millard-
I use the word compassionate appointment?
No, Millard,
And saying that,
Millard, that's where the dispute lies, Millard. The
And
job.
then saying that she has he has no other persons.
Millard,
She went forward and filed a suit. I do not know.
Millard,
All the benefits
Millard,
have
the
been
job.
taken away.
Millard, the job was a bodily job, which Millard is absolutely customary in nature, which Millard, as per the prevalent practices in all the tea gardens, when someone dies, the job should remain within a family member who is residing within the garden, so that the job does not go up.
Who can
Millard,
be
from
said
the-
to be- You said that after the death she left.
She
and
left.
started
Millard,
residing in
Millard, that's
in
borne
her
out from
parental
the-
house.
That's Millard borne out from the evidence also. Millard, whether she had waived her job, Millard, number one. Number two, Millard, if she had waived her job, Millard, whether she will be entitled to, because she is the only family member who was residing within the garden during that relevant point of time.
Sir, kindly tell me, what is the definition of a family in a modern society?
Millard, from family includes the
So-
immediate
so
members.
I am
Family-
asking, I am again saying, what is the definition of a family in a modern society?
Millard, the family includes Millard the immediate descendants. There is no doubt about it. But Millard,
So who,
it's
a
customary practice,
a
Millard.
father died and the daughter would be left.
No, Millard, it's not the daughter, Millard, it's the wife who is claiming the job.
Sir, I understand.
Yes.
That means for the sustenance of the daughter,
Millard, she had
who
left.
will maintain the daughter?
Millard, she was not residing within the garden at that relevant point of time,
That
which
is, that
prompted
is
Millard,
immaterial.
the management to Millard give the job, Millard,
Can't
to
give.
her daughter-in-law.
Can't get.
To his brother's wife.
Our he has left the wife and a daughter, see his sister-in-law, and the sister-in-law has subsequently remarried.
Millard, from the evidence, Millard, is borne out from the Millard deposition that she has waived it expressly, that she does not want this
And
job.
you have also remarried.
But I am residing within the garden.
After remarriage.
Yes, my lord. And the entire concept of Badli job is that the job should remain within the garden, it should not go out. That's my lord, the only ground, my lord, where we have my lord approach.
Home to be accommodated on the death of a worker is a family. And the
Right.
family consists of a widow and the daughter. If the widow wanted to work, she will live in a
She
garden.
waived it.
She will live in a garden, don't worry.
My lord, she waived it, she left.
That
And
is
my lord,
between a management and her. But this cannot be done.
my lord, on this point, my lord, whether it amounted to a my lord
There is no law.
waiver.
There is no law. Waiver is a very relative term.
Right.
The waiver has to be constituted. She has come forward and filed a suit. That means that she did not waive it. She is asserting her right. You have made the management to understand that this is what the scenario and got the job.
There were written documents on record, my lord, where she had stated to the management that I don't need the job at this point of time.
That was she has said under caution.
No, my lord, that's disputed. That's disputed.
And the court has found that it is.
And my lord would find, my lord, when the court has scanned the evidence, my lord, there are contradictory findings.
Is the point. I've gone through it. Anyhow, yes. Dismiss it over the Dismiss my brother will dictate. As for orders, day after tomorrow, go ahead. Yes, call the.
In item number 15, my lord, Nobangpur Pal is appearing in this matter, my lord. On his count, I am waiting for an adjournment. Mother has expired.
Have you served?
My lord, I'm not
Who's the
aware.
advocate on record?
Nobangpur is the advocate on record.
There is no other person. The service.
My lord, may I take the instructions from him? May I call him back?
This is a condonation application, so we can activate the
My-
process, nothing more than that. We
My-
are not going to decide it,
My lord,
but at least the service we can direct
may I take the instructions from him?
tomorrow. Sixteen.
My lord, may I, on intelligence matter. His clerk has stated to me that the service has been done.
There is no direction. How can you serve without the direction of the court? This cannot be done.
My lord, in that event, my lord, let it be in the next again.
Puri, what are you talking?
Because
We are thinking of, talk to him, that if we direct the service to be affected, at least the service can be affected through him.
man,
Only thing is a covering letter. Is he not in a position to sign the covering letter?
man, that
So, and it will automatically go to the next circuit, but we can, process can be activated.
pleasure.
Hey, it finds that the instant appeal is filed beyond the statutory period of limitation provided therefore, accompanied by an application for condonation of delay. The applicant is directed to serve the copy of the application for condonation of delay upon the respondents by speed post and shall file the affidavit service on the returnable date. The application is made returnable before the next circuit bench. This is what really. we
Man,
wanted to
deeply
do.
obliged, man.
Next.
My lord, item 16, my lord, Mr. Prantikos is appearing for the appellant, my lord. Only a short passover, my lord. He is coming from Chesky Centenary building, my lord. Only a short passover. My lord, I am the advocate on record, my lord.
Do it.
My lord, all right, my lord. My lord, the present
Just 1
appellant,
minute. Give us.
my lord.
Sir, it is not expected that you are on virtual. I find lot of noises from behind.
My lord, I apologize, my lord.
For the other side.
My lord, I beg to appear for the response.
Don't, while you are using the word big, I have indicated that don't use these expressions. You have a right to represent, say straight away, I am representing.
My lord.
So now the question is, are you ready?
No, my lord, I have.
Are you ready for the main matter?
No, my lord, I seek some accommodation because there are certain facts which
I do not want to know what is there is there. Are you ready with the main matter?
Not today, my lord. Kindly some accommodation.
Tomorrow, will you
Yes,
come
my lord.
ready?
Yes, my lord.
We'll
Tomorrow-
dispose of the appeal at the admission stage.
My lord,
For
tomorrow-
that I am asking you.
My lord, tomorrow I'll be prepared.
Come ready, tell him to come appear tomorrow in the main matter.
My lord,
Yes.
and I'm grateful.
Not today. Not on section 5, main matter.
My lord. My lord. My lord, I'm filing my Gopalatnama. Grateful, my school.
Just 1 minute. First, we cross the hurdle of admission. If it is not admitted, where is the question of stay application? Just one. Yes, what is the point? Are you on a admission?
This matter from the learned trial could matter hold that the declaration of the 1/5 share of the plaintiff, which was explained in the grade, that share, that declaration of the share of the plaintiff cannot be possible unless matter the partition is paid for. Whereas matter on the other hand, that trial court holds matter the transfer of the unpartitioned undivided property can be made, which has been made by the defendants matter.
No, there are two concepts. There is no embargo in selling the share by a co-sharer in respect of a joint property.
Yes.
This is one.
Yes.
But is there any fetter that's a suit simpliciter for declaration of their undivided right title and interest without claiming a partition is hit by section 34 of the Specific Relief Act? Because the appropriate remedy is the partition.
After declaration, the partition can be.
Why? That is what I just wanted to know. Can you show me a judgment? Because I know some judgments against this principle. It says the suit simpliciter for declaration of undivided right title and interest is not maintainable unless you seek for partition.
So, contrary, when dismissing the suit, trial could say that the declaration cannot be made without partition.
True.
Whereas the trial court has stated that observed that the transfer of the unpartitioned property can be made.
Yes.
Thereafter.
No. This is what is something else. But I am just asking you, section 34, will it, these principles show us that the suit for simpliciter declaration is maintainable?
And one more thing, the stay has not been filed, so
Not necessary. First, cross the hurdle of admission. Cross the hurdle of admission. Tomorrow, Day after tomorrow, you, as you asked for time, day after tomorrow. Not today and tomorrow. Come with this principal, show us, no difficulty. Consequences will be great as well. The other release, section 34 provision. 18.
My lord, in this matter, my lord, on behalf of Navampur, my lord, there is a section 5 application. Is there?
Sir.
Yes, will there be a direction, my lord?
Service. There is can one. Take records, can. Where is a combination application? It's only can two which has come. What has can one? Can two. Which department কি করছে? What the department যে পাঠানো হচ্ছে কোথায় আছে can one? There is a can two. An order does not reveal the can one is disposed of. Can two তো আসবে না যখন can one না থাকলে. Then where is the record can one? না আছে can two না হলে হবে না can one ই হবে। Can two already করে। কিভাবে হবে? Where is can one? Section नहीं.
My lord, the list shows that there is a can one application.
This, but there is no can one with us. Oh. Bring that can one. Can one Tana. We are just keeping it Passover.
Fine.
Can one let it come?
Fine.
Next. Basically two, no, please. Basically one. Typographically, basically one. Sit on the hot level, like always just like a order. We are on going to party, not a necessary allegation is against the defendant who is trying to dispose. And we have to whole option. Where is Mr. Shubhas? Shubhas is Mishro. Anybody knows him? Under the care of Satvik Bhattacharya. That is what is the problem. Everybody gives a Kolkata address here.
Not presently quoted.
Mr.
Not presently quoted.
Where is he? Anybody knows? Do you know him?
He sits in the bar.
Can you contact him? Tomorrow we are keeping this matter.
You can bring this to
Thank you. Anyway, just inform him. Not today. 20.
I'm appearing for the respondent.
Oh, that means that you have a very, very tough and a bad case. Just 1 minute. You have filed a revisional application without knowing order 41 rule, order 43 rule 1R. And let us just go through it. Now the question is, I tell you, is it an appellable order? An application taken out in a miscellaneous appeal is an appellable order, application for injunction.
My application for injunction was turned down by the first appellate.
That's right. It is an independent application for injunction filed in connection with the miscellaneous appeal.
Yes, sir.
Miscellaneous appeal under order 43. Correct? If the injunction is refused in the miscellaneous appeal, is it an appellable order under order 43 again? Because of section 104 embargo, no further appeal lies. Have you seen 104 of the code? ये दो कोड तो दिए दो कोड सिर्फ प्रोसीड्यूर तो दिए दो हट बोल दो Section 104.
Orders for which
An appeal lies. Please read. No further appeal lies.
an appeal shall lie from the following orders.
Correct. Correct. Then
They when accept, they when otherwise express.
sub-rule 3, read. Or sub-rule 2.
An order under section 91 and 92 refusing leave to institute a suit of the nature referred under.
No, then 3, read.
An order under section 95.
No further appeal lies. Read that subsection, sub-rule.
Provided that no appeal shall lie against the order specified under clause F, save on the ground that no order or an order for payment of.
Sir, I'm talking about sub-rule. You are reading sub-rule 1, several clauses.
Sub-rule 2, no appeal shall lie for
Correct.
any order
Sub-rule
passed
4.
in appeal under this section.
Absolutely. So it is an appeal under section 104. How an appeal lies? If now the principle is that if the appeal does not lie to a final order, whether an appeal would lie against the interlocutory order. Suppose if this appeal, miscellaneous appeal is decided, whether the further appeal would lie. Section 104 says no further, revisable. If from the main order, the revision lies, then from an interlocutory order, appeal would lie. I'm asking you this.
Earlier 227 was filed before this.
I understand. I understand. That's why I'm saying I know your predicament.
Matter came up before justice.
I understand, but the difficulty, that's why I'm asking. ও তো convert revision ই করেছিল ঠিকই ওকে convert করে দিল appeal now I have to again reconvert it to revision. Bring that judgment of Sir Asutosh Mukherjee, bring a judgment of Justice Bhaskar Bhattacharya, bring a judgment of Justice Sumir Kumar Mukherjee. These are the 3 judgments on this. We'll have to bring it. and somebody says that no, revision does not lie, and you accepted it without applying your mind. I'm telling you, the principle which is there is that if against a final order, the remedy is not an appeal, then against an interlocutory order, the appeal does not lie.
Can be same be treated as
It has to be, but now once the judgment has come, because you correctly approached the revisional court, now it has been converted into an appeal. If we have to say, then we'll have to say referring those judgments, or should we find a judgment, or you will help assist.
Kindly gives me 1 day.
So that's why I'm saying, bring those line of judgments so that we can say that these are the principles of law applicable, so it has to be not forgetful. For the next. What is defect? Service, have you filed application?
Yes. Not a
Can you affect earlier service? Can you do it shortly so that it can be disposed of in this circuit?
Yes, sir. Kindly do.
But there is this was added drip.
Yes, sir.
So there is, have they appeared in the meantime?
No,
They have not. Then
no.
service, let the matter be lifted on next Wednesday. Wednesday week. Wednesday week. By speed post, you serve.
And I can know 23 also.
Let us call 22 first.
22.
Same defect. What is the defect, sir?
I don't know,
But your junior must have gone through the record.
he went to the office, they said he during lunch.
Sir, there is a deficit court fee of 160, sir. Where is 160 rupees?
It will be done.
The report of the additional staff reporter indicates that the instant appeal is filed with a deficit court fees of rupees 160. Time to put in the deficit court fee is extended till tomorrow. This is the matter on Wednesday.
Wednesday. My fifth answer, this 3 days, let it tomorrow, why?
Tomorrow, in course of this day. Tomorrow, next. 23. 23. Control the delay of 26 days. Service. Just a week. Next.
Sorry, Lordship, I have my
No application.
My lord, it is ready, my lord. There is some miscommunication between me and my clerk. My lord, I
No,
have
my
filed.
officers
Yes,
said
yes,
that
yes.
there is no applications filed.
Right, my lord, it's mistake from my part, Lordship.
What can be done?
My lord, I am filing it, Lordship. Kindly
File
take
it today itself. File it.
My lord, can you please open up there tomorrow in that case?
File it first, madam. Go and
Supplying
then supply
the
it.
number, Lordship. Grateful, your lord.
Next. The Passover matter is there. সেটা not today করে রেখে দাও just any Passover matter is there. দাও কল করো Where is the can? Have you filed it?
Yes, my lord, it's appearing.
Then come tomorrow, let us see. Come tomorrow. Yes, call item number 24.
Which for the state?
Where is the additional government, I mean the public prosecutor or public prosecutor?
Item number 24, 25, and 26, it clearly says a substantive question of law
Substantial question of law.
was raised. And against the same, the hearing was.
It stands before dismiss. What is this?
But
The earlier
the
one.
question was whether non-compliance or
Lordship.
non-compliance of section 42 of the NDPS Act.
Lordship, paying for a short passover, Lordship.
What?
Mr. Obijit Sarkar is in court number 3, Lordship. He is in matter will be.
So let him argue.
The question was, Lordship, total non-compliance of section 42 of the NDPS Act, if there can be granted. Now, certain points were raised from the state regarding stating that Nawaz Khan's judgment and recently Honorable Justice Bela Dwivedi's judgment proceed, stating that those are matter of trial. But Lordship, we have certain points to approve that even at the bail stage, those points can be considered as because those points it's
Ignoring the judgment of the Supreme Court.
The 6th judgment.
Now you say that we were raising these points. To that I say that ignoring the judgment of the Supreme Court. If the Supreme Court has said that these are matter of trial, cannot be a ground for granting a bail.
Here I submit the judgment of Nawaz Khan. I humbly submit Lordship to my.
That was by Justice Aniruddha Bose.
No, Lordship, it was by Justice Chandrachud. But that time he was not the chief justice. Subsequently, Lordship, I submit it was passed with ignoring the fact that on the same point, equal number of bench gave another view.
Earlier. So you want to say per inquiry. And what about the subsequent judgment? Kasim?
Deals with completely different ratio. It's a non-compliance of 52A, which on various contexts have stated that even that
But there was a general observation that it should be applied other matters also.
I have replied to my legal understanding on that.
So even an arbiter applies and has a binding effect. Unless it is an arbiter to that extent, which has no bearing or no access.
My point is that at the present the judgment which we are referring, that non-compliance of 42 the trial initiates the Supreme Court. Even we have the judgments of Supreme Court earlier, which says even at this bail stage, non-compliance of section 42 helps the accused for obtaining a bail. But that judgment has not been considered in subsequent judgments.
I understand. What about Kasif? Was that judgment of Kasif? We are also ready to hear up. Don't worry.
State is not ready.
Where is it?
Three matters.
Who is appearing?
In one matter, Mr. Sarkar is there. In other two matters,
Yes. Who is there to respond? Are you ready? Are you ready in your business? Only with a CD and nothing more than that?
Yes. CD and also judgment of the Supreme Court.
Yes. Show us. Show us.
What is the quantity of contraband articles?
Or above commercial.
Above commercial. But in three cases,
যখনই 42 বললো তার মানে above commercial quantity you want to wriggle out of section 37.
What is it, Ganja or?
Lordship, three matters are different.
Oh.
Lordship, I was thinking to start the case from the Baljeet Singh judgment.
In this case, it has
No,
been.
no, let us see first.
See.
Pass it.
In this case, it has been mentioned.
I'm coming to that.
Just a minute. Hell is the exception. Hell is the rule. In this.
Ulto.
Any lapse or delay in compliance of section 5 itself would neither vitiate the trial nor would entitle the
Needs to be paragraph 36 is beneath the votes. Yes. Yes.
Lordship, to my little understanding, that infinite judgment of Kashif revolves around 50.
Can I have each LDPS act?
I know indication. It has to go.
Yes. Yes, sir.
Lordship, to my little understanding, this case of Honorable Justice Bela and Trivedi and Justice Sharma in Kasif, Lordship, revolves around section 52A and section paragraph 34 is the main paragraph where the court has expressed their opinion relying upon Union of India versus Mohanlal, which is a pure case where section the operation the section 52A how to be applied and how those are maintained. And Lordship kindly says ultimate para 39 where certain guidelines have been given.
Read paragraph 36.
36,
Which is
Lordship.
a very important one.
Once again, Lordship, this entire 36 relating to section 52A.
Please read. So one has to be considered in this. That if there is any kind of a procedural lapses. Then in that event, according to this judgment, that does not really confer any equal right into a person to obtain bail. It simply says that you can take a plea of
During trial.
Non-compliance. There is non-compliance during trial, but it does not vitiate the trial. 52A is because they said that all these judgments, Mohanlal and all, everything was taken
Lordship.
without noticing the constitution-based decision of a larger forum.
Lordship.
And which is there in Sivaranjit, and also where there in case of the use of
Lordship.
taken into consideration.
Lordship.
39 you are referring, which you are referring is say around clause 2, 3, but I am referring clause 5.
Clause 5. Yes, Lordship. Clause 5.
Application of the rule.
Yes, Lordship. I am trying to give the answer. First, paragraph 36.
I am more on 5.
Yes, Lordship. I'm first paragraph 36, Lordship.
That is what I'm saying.
Paragraph
36.
Lordship.
Read with in conjunction or should be read in conjunction with 5.
Yes, Lordship. First, let me give reply to paragraph 36, what has been fallen from the mouth of my lord.
So 42 talks about the officer who can go there and
now, Lordship, section 36, once again, I humbly submit.
Bottom line of the story is that there was a contraband about the commercial corporation.
Yes, so 37 has to be,
from your position.
yes, 37 has to be curtailed. 37 has to be diluted for granting.
So reverse presumption is there, sir.
Yes, Lordship, but reverse presumption cannot. Presumption cannot. If Honorable Court thinks that there are certain things which has struck to the base of root of the case and violated Article 21, 37 cannot stand in the by way.
That is why Justice Bela Trivedi has said that the bail is exception.
Yes.
And the jail is a rule.
Lordship, one second.
In case of NDPS.
One second.
Because of the object, purpose, and the impact which would create in the economic development of the country or the human resources to have in future. These are the things which have to be taken into consideration. In normal situation, there is no question of reserve presumption. It is the prosecution who has to prove without any reasonable doubt. But exception is carved out in NDPS reverse presumption, because it is you from whom the
article has been
you have to prove it.
Lordship.
Because the presumption is against you that you
Lordship.
are the property.
That is the matter of trial, Lordship.
This is why 42 says that who care is an officer. You are saying that this gentleman was not a person named in 42.
No, Lordship, I'm not saying that.
Right?
The first let me answer section 36, paragraph 36.
No, first you answer 42.
Lordship, 42.
Why you say
what is the difference?
Is your
yes, Lordship.
Versus the CD, there is no irregularity in the CD, Lordship.
let us see what he's wanted to say.
Lordship, my humble submission is that non-compliance of section 52A as in
I
Kasif,
am, asking in your case, you say 52A is not applicable.
not applicable.
You are taking a plea under
42.
42. What 42 says? Tell
Lordship.
me and what is the violation?
Lordship,
Tell us.
42A says, 42
42.
says, there are two subsection 42, 1 and 2. As soon as the officer takes down any information in writing, he has to send a copy of the same.
Correct. That
to
is
his
what I'm saying. The
superior.
procedural one.
Now I'm coming to that, Lordship. I'm coming to that. Belaim Trivedis, Honorable Justice Belaim Trivedis Kasif will not come into help as because Constitutional Bench of Supreme Court has stated that non-compliance of 42 the trial vitiates.
Where is that?
Yes, Lordship, I'm coming to that. I'm coming to that. This Kasif will not stand in any way, Lordship.
Yes, show us.
First,
Show us.
Lordship, may I take your Lordship to State of Punjab versus Balbir Singh, long as that as 1994.
Show us.
Thereafter, Baldev Singh.
Balbir Singh.
Thereafter.
I'm coming to it. He did show you. Balbir Singh dilega. Balbir Singh, what is he dilega? Lordship says it international. Balbir Singh.
No.
State of Punjab versus Balbir Singh. Over delayed. Correct. একটা কপি আছে আপনি কোন গ্রুপে দাও কপি ওটার
Let's give it.
On the last occasion, so was it? Here. Kindly see, Lordship, para 8.
Let us see. It is a two.
No, Lordship, I'm coming. This is
When you're talking about a
constitutional. I'm coming to that, Lordship.
You'll have to consider.
Colonel Singh, that's Colonel Singh. I'm coming to that.
Please
First,
show us.
First, I want to show Lordship this
Para 8.
para 8.
Now, is this judgment of Balbir Singh taken into account by the
Kasif.
in this Kasif?
No,
That is what I really wanted.
because Kashif does not deal with section 42. So
Maybe the principles maybe up.
But-
Balbir Singh was taken into account, like in Kasim.
Baldev Singh was
No, Balbir Singh's case is also there. Okay, you please complete your submission.
Lordship, only is para 8 first. Then Lordship, para 25.
Yes, one.
Well, now to para 25 question, 25(3).
Yes.
Lordship, only, Lordship has seen para 25, subject three. Now, Lordship, next I am referring to whether what is. Lordship, in the judgment I was mentioning that constitutional bench judgment of Colonel Singh. Kindly see Lordship para 35 A, B and C. Para 35 A, B, C.
How it helps you?
Lordship, para 35,
I have seen.
total non-compliance is impermissible.
Oh,
And here in our case, all the three cases, there are total non-compliance.
it is not paragraph 35 which says about this.
No, this is a factual aspect that can be.
These are the distinction which is noted in Abdul, this
Yes,
one,
sir.
Rashid, and
for your
the
case,
Sajjan Abraham's case. Totally different. And this is what the summarization comes under paragraph 35. It does not lay down. The reference was that whether the Abdul Wahid and the Sajjan, the Abraham, both are contradictory to each other. Contrary. The court says no.
No.
It is in a different special factual situations it arises.
So, Lordship,
And nowhere it has laid down the constitution means that non-compliance is.
Lordship, para 35D,
I've seen that.
well, total non-compliance with requirement section, subsection 1 and 2 of section 42 is impermissible.
Oh, that is what is impermissible, but what stage is the matter of trial or at the stage?
I'm coming to that also,
That is
Lordship.
not.
And we cannot cut short the criminal trial, okay?
No, I'm
That is the-
I'm not asking for quashing of.
And please, last line, whether there is a adequate or substantial compliance with section 42 or not is a question of fact to be decided in each case.
Each case.
Then the factual aspect can be decided.
No, we can't. If that, if there is a sufficient or some compliance is there, we can.
Lordship, kindly seize Sarija Vanu. Sarija Vanu, 2004.
Necessarily you are.
42 to comply, your lordships, already.
So this has, the compliance has come.
No, Lordship, this is not compliance because I have judgment to that effect that the extract of GD is not compliance. Supreme Court judgment. Extract of GD sent is no compliance at all. And bail was granted by coordinate bench also on this point. Lordship, kindly see Sarija Vanu first. Comply.
Let us come back at 2.
ये judgment
As the interim order will be expiring, it expired yesterday. As in this court division bench district of 200 cases. With court number 4.
Don't underestimate the pace of the court.
No, I'm not, because on the last day, on last circuit, I faced that problem, that is why I.
Oh, no, don't worry.
Oh.
Which is the matter?
It's item number 2, under the heading extension of interim.
It is not listed today.
Yes.
Item number 2 we called.
The court number 4.
Or then you, oh,
Yes.
don't worry,
Of that.
don't worry. Yes, can we have a dedicated day for hearing of this matter? When? Day after tomorrow, we will hear out all, give all the judgments, so we will prepare ourselves beforehand. Don't worry. Give all the judgments. Here. It's a copy of the GD.
Sarija Banu, you have filed, no? Sarija Banu.
Even at the bail stage.
What are your judgment? What are the weapons in your armory? What are the, give all the weapons? Not. I have a bad habit of reading from first sentence to a last sentence. Yeah. Do one thing. Do one thing. Take all this
Yes.
and make it one after another. Just write P. P, no bullet. Make a P and you write a R. At the top, you just write R, you write P. Day after tomorrow. ওটা দুটো সেট আলাদা করে দিও, দুজনকেই পাঠিয়ে দিও কালকে।
How long you are in custody? Sir.
There are 4 matters, all are different.
So, fast, only one person. So, you are not ready.
In some.
Yes.
More about a year, some more than a year.
Oh.
You are 24, 25, 26.
All same point.
Yes, 36.
24, 25, 26 and 32.
শুনবো ওটা তো কোর্টের পর এটা সব ডে আফটার টুমরো জাস্ট চারটে কি ওই চারটে কি ওটা ডাকছি না তাহলে মঙ্গলবার না কল 27
Number 27.
I am for the state.
Your Lordship, praying for 1 day accommodation, Your Lordship.
What are you doing, sir? You did not appear on the last occasion, 14-2.
Your Lordship, actually, I don't know the matter about. I just instructed to take.
Who has instructed you?
My senior,
Who is he?
Anirban Banerjee.
But where is the advocate in record? Anshunara and Sake.
That I cannot.
You cannot say, then your senior can't appear without his instruction. This can't be a ground of adjournment.
Just pass over for a few minutes. I'll just follow.
Pass over for 15 minutes.
Grateful.
I can 20, I want to not tell this.
I am appealing for this statement.
Recently, the Supreme Court has deprecated this. That in the garb of a not press, then suitable benches, again application deprecated it. What to do, sir? We are bound by the law. What
Then
to
make
do?
it not to the man. Not tomorrow,
Do it.
not tomorrow, my lord.
Oh, why today?
Not tomorrow, I'm not saying that I'm not doing, madam.
Why not
Tomorrow.
today? Why not
Not
today?
tomorrow, I'm not. I have instruction to not push and I not directed to, you want the accommodation, I will do this matter tomorrow, madam.
This is fine.
বিকেল হয় সেটাও একটা কারণ ইচ্ছা করে এবার করবে বিভিন্ন রকম ডিসিশন করবে তারপর সিটি চলে আসবে এখানে
Tomorrow, first matter.
Hey, nobody is here. Ram Prasad.
No, Sudeep Guho. Where is Mr. Sudeep Guho?
আগে ওই অনেকটা করে দিত আগে
The first time application.
20 bottles of cough syrup with 400 capsules, commercial quantity.
Where is Mr. Sudeep Guho?
I have not seen him today.
Otherwise, we'll appoint one person from the State Legal Services Authority.
Madam.
If it does not appear, then we can. Make it not today, otherwise.
Thirty,
30 minutes, I am appealing for this statement.
I'm paying for not to the man.
DPS sector, our check. How is it?
Tomorrow, only tomorrow. Thirty-one.
Sir, I am state lodge.
There is who is 31, number. Shubhasis Mishra. Shubhasis Mishra.
State is very well.
But where is the petitioner? The state is ready, the court is ready, but the petitioner is not ready.
NDPS commercial quantity, my lord. 24 kilograms of gaja.
20 kilograms.
24 kilograms. 24 kilograms, 600, 24 kilogram.
Since when he is in custody?
My lord. Was arrested on 16/10/2024, my lord. Investigation is going on.
Since when it will continue? How long it will continue? Now,
Yes, sir.
November. So.
But I pray for 1 day accommodation.
Yeah.
180.
180 days is the statutory period of 80 days. 180 days.
180 days.
Yes, madam.
Unless extended by under.
It can be extended up to 1 year, madam.
Yes, understand. 180 days means
180
months
Yes.
practically.
Mean time is required for obtaining the certification from the CFSL, my lord. This is the reason the delay is caused.
Yes.
1 day accommodation, my lord.
Why?
I'm not prepared, my lord. Tomorrow, my lord. Kindly
You
fix
are,
it tomorrow.
you are in many matters, you are not appearing. Even in civil matter, you are.
But civil matter,
Mr. Tapos Kumar Bhattacharya, but you are not appearing.
but civil matter, my lord, I was on the way, my lord, that I could
Not today.
not sure.
Lordship, in 33, I'm praying for 1 week accommodation. Not kindly, Lord.
My lord, state is ready with it.
So. I think you asked for the same accommodation.
No, Lord.
Yes, on 21/2, adjournment was asked for.
Because a hearing was held.
No, it was said that in course of the hearing, Mr. Ghosh appearing for the petitioner prays for an adjournment to avail the necessary instruction through Mr. Missas. Now, so means you are ready, you do it, and your name is Angana Rokhit.
Yes, sir.
You also appeared.
Lordship, I do not have instructions to proceed.
Then we can worse.
Lordship, I do not have instruction to proceed with the matter. If
Why? You are the
kindly,
advocate in record.
granted some
Oh,
adjournment.
you are not an advocate in record.
No, Lordship, I'm not.
Can't be like this. Do it tomorrow. Take back. Again. Yes.
34.
Lordship, I'm for the petitioner.
Even for will. It's not NDPS. It's not NDPS.
No. This is a
Miscellaneous.
this is no another case. This is a case under 376, Lordship. The victim girl was 28 years old and the petitioner is 25 years old.
I am for the state, my lord.
I am for the defendant company.
I am for the petition.
My lord, I also appear for the de facto.
Yes, you will appear, but
What is the?
My lord, the case is initiated under section 498A 303. There are more than 25 witnesses. He is in custody for more than 4 years, 6 months. Only 4
How-
witnesses have been.
How the week, I mean, your wife died,
My lord,
how your wife died,
there's an allegation he has,
the allegation is there, that's why I'm asking from the record, tell us that how she died.
my lord. There's an allegation that he has,
I have filed some documents, so. That applicant will his wife.
Brutal murder, my lord, brutal murder of wife. Examination of witness have already been started, my lord, 4 witnesses have been examined. What? Brutally how? With what? With a sharp cutting weapon, kachi dao, body dao. And
But
recovered
lordship
from
kindly,
he
my
died
lord,
on the spot, man. Recovered from.
Yes,
it has recovered,
on his-
shown by the. On his disclosure. Yes, my lord.
No,
That was recovered.
Yes, ma'am.
Yes.
and my lord,
Only 4
that
witnesses.
the woman
During
received.
this, when charge was framed.
My lord, there is some delay, I admit.
Then
My lord, we'll.
there are several
We'll
decisions of the Honorable Supreme
Now,
Court recently.
recently the trend has come that the High Court should not expedite the trial in that sense, and they must decide the application.
I have annexed all the orders.
On its basis. Yes. It has to be left.
It
to
was,
the
it
wisdom
was
of the
fixed
trial.
for
So-
charge on
Okay.
13th January 2020.
How many witnesses have been examined, and do you
Four.
have the copy of the statement? No, I do not have the copy. They have a children? Yes. Whether those children, how many, what is their age? Who's accused, my lord?
No, children. Children.
Sir, it is a matrimonial offense.
Yes, my lord.
Serious matrimonial, so they must have a children.
Who got children?
Yes.
Who got?
How many, what is their age?
Both of them are minor.
What is the age?
Age is about. One is,
Yes, they are staying with the maternal aunt, my lord.
yes. At the,
Around 9-10 years old, my lord, they are staying with the maternal aunt. Any statement was taken? No, the children's statement.
So, you have, my lord. No. You have the CD. Why
No,
you
I
have-
have got this, I have gone through the city, my lord. I didn't find it.
498A,
Confirmed. This is not expected from him. Sir, this is offense related to women. We do not allow this virtual hearing to be done.
Lordship.
Sorry, we do not.
So my lord,
No,
kindly.
sir,
keep-
we do not
Yes,
approve that.
yes,
The
yes.
Supreme Court, the model, the rules.
My
which
lord,
is
my lord, I fully understand. My lord, kindly keep this
No.
tomorrow. I will
For
appear.
children or a woman, and more particularly when it is a 498A, should not be.
My lord, it is at virtually 302, not 498.
No, 498 out of the matrimony
My
relations.
lord, I would request
No.
your lordship to keep it tomorrow so I can appear
You
physically.
appear in person, this is not, we don't
Lordship,
allow this.
kindly keeps it tomorrow. I will appear in person.
More particularly women related any offense or
I fully understand, my lord. I
we
fully
do not approve this virtual hearing.
So my lord, kindly keeps this tomorrow. I will physically appear before you.
before by your lordship's bench on my lord September 24. The order is at my lord page 20. The prayer was rejected, my lord. Herein, my lord, the plea under section 479 of the BNSS, which my lord stipulates that if 1/3 of the maximum imprisonment is my lord suffered by the petitioner, then my lord he shall be released. However, your lordships were of the opinion that that bracket has not yet been my lord suffered by the petitioner. My lord, as on date, I am 800 days in custody, only 170 days short of this 1/3 period. And after your lordship's order, there has been no progress in the my lord proceeding before the trial court. Lord, I am protected by Ravi Prakash's judgment of the Honorable Supreme Court.
Oh, this is the third application,
My
or
lord,
fourth application.
yes, Lord. Fourth up.
The earlier three applications were dismissed.
And the last rejection was by your lordship's bench on September 24. 5th September 24. However, my lord, after that, there has been no progress. What remained as on September 24 is still the situation today.
Yes, what is this going on?
Now, first of all, in this case, this the petitioners, he has applied for an Indian passport. And while at the time of verification, it was found that he is a citizen of Bangladesh. He has entered India, and he was in one of his relatives' house. That is one Girish Mahanto, and showed him as his father. He took a fake certificate from the school. Thereafter, he applied for the voter card, which was later also voter list. His name was deleted. And all these documentations were made with the help of this Girish Mahanto. Thereafter, he applied for, but it was found that he is a citizen. Now, 468 is there, my lord, 468 and 471. So 468, the punishment is 7 years. Regarding the quantum of punishment,
charge sheet was filed?
Charge sheet was filed on 19th of February 2023 under 14A and 14C.
Charge was framed?
Not yet, sir.
Then, so you will keep him indefinite incarceration. What is the reason for not framing of charge? Sir, punish them, convict them, no problem.
Next date charge, next date is on 27th of, it was on 27th of February 2025 for opening of the prosecution case and consideration of charge.
Only one.
Which did
What
not happen
happened
on
on
that.
27? Nothing.
Nothing.
They are not responsible
Now
for the
he
delay.
is a foreign national, my lord.
So what?
Now if he is granted bail, my lord, once he comes on from the jail, again he commits an offence under the 14C, my lord.
Judicial decisions of Honorable Supreme Court in
And I
this
know
regard.
that.
My lord,
He has to be
Frank
deported to
Witness
his
is
country,
judgment.
my lord.
This
That
year
is the
itself,
only provision
the
as he
Honorable
has to be
Supreme
deported
Court
to the country after
has
the
passed a
trial.
judgment in Frank Witness's case, where the Honorable Apex Court says that once a case is made out for bail, even if the person is a foreigner, he is protected by Article 21. In Frank Witness's
That was a case of overstaying on visa,
that was a
my
case
lord.
of NDPS.
That is under the immigration, that is separate.
That was a
If
case
you
of
have a
NDPS.
valid visa
I'll
which has
show you
not been
lordship's
extended for your
Let me place
overstay,
the-
Immigration Act is there. But when you are an illegal
Allow me
immigrant
to place
without
the
any
judgment.
documents you enter, and for Foreigners Act is there, my lord.
In
So that
Frank-
is totally different.
In Frank Witness versus NCB, the my lord offences were
I'm
under the
saying only on
NDPS
the
Act.
basis of Article 21 as espoused by.
Whether he will be guided if he is a foreign national under.
Yes, there are
Article
judicial
21, my
decisions.
lord.
Go through this.
That is different. That is a visa overstaying in India without applying for extension of the visa.
No, why you have-
There Article 21 will be applied.
Why you have failed to frame charge? He is the only one accused. Whether they are responsible for the delay or you.
That I have to call for a report, my
Why?
lord, why there was a delay.
You
Because
must be ready
I have to
with all
call for a
these
report from the
instructions.
lower court, my lord,
Not
public
lower
prosecutor,
court,
my lord.
sir.
Oh, trial
District
court, my
court.
lord, trial court.
Yes.
Lord, page 8, the last paragraph, para 7.1. Page 8, last paragraph, para 7.1.
170 is there, only 130. If we take that stand, my lord, 1/3 after 7 years and at least.
And my lord, the present issue is at para 11.1, page 12, the last paragraph.
Yes. Why it has not started? I fail to find any reason therefore. I have gone through this judgment. We'll definitely deal with this judgment that how it applies, in what situation it applies. But at least we must be very sure about that, despite the orders having passed consistently, why it has not been done. And there are connected cases, many people have already been granted bail.
Yes,
Who are they?
all the other accused persons.
India.
They have helped,
Yes.
they're just Indians, my lord. They are against them with amendment, my lord, those sections. But here,
Those sections, they are at par with that.
my lord, here he's a.
Yes, my lord, abatement
He has been
or
established that
abatement
They are at
time
par.
of
punishment is same.
application.
Only rescue is Justice Aniruddha judgment.
Give us some time, then, by next week, we'll file the report why there was a delay. Maybe for whose reason, what is the reason for the delay?
He's taking time for filing instructions.
What has happened on 27th?
The charges were not framed, not attributable to us. We were present in court, but the charges were not framed. There was no adjournment.
Who is the judge?
My lord, this is pending before. My lord, fast track, additional district judge, fast track court, Shiliguri.
What is doing when the date is fixed for framing of the charges, why the charges are not framed on that date? All the accused are before the court. This is not expected. They would come and go and no significant progress is done.
The report নিতে হবে। তাকে photo দিয়ে এরকম ছেলে রেখে দেওয়া সেটা কি ঠিক?
Though I'm not sure, but unofficially, my lord, on 27th, the landed district judge from Darjeeling, he came down, there was a meeting with all the judicial officers in Siliguri. Maybe that must be one of the grounds. But whatever,
Judicial
matter, we'll
officer,
check it.
this meeting during
I'll
the
check
judicial
it.
hours
I'll check it.
is not expected.
I'll just take information from the concerned people.
Tomorrow, take information today itself.
And if
To consider it. Later on, we will try to look it up.
On record, have to leave for serious medical condition that has erupted out of previous ailment.
Make an alternative arrangement. Make an alternative.
Your lordship, then at least on Monday, your lordship.
Because every time you are asking for an adjournment, last time also on your prayer. How many circuit you want for this matter?
This is the first time it has appeared.
No, sir. On 19 to 2025 on your prayer, it was the next circuit. So how many circuit you want?
Time is also going on, madam.
Mohammed Shoaib Akhtar appeared for the petitioner.
Apologies, your lordship.
So
Your lordship kindly fix
how
on
many-
Monday because he's not
how
over
many-
here.
How many days you want? How many circuit you want? So we will adjourn for that, it will not be taken up in incoming 3 circuits. Tell us when he can be able to do it.
Your lordship, he left. He's not over here. That's why.
Why he has left?
He knew it
When-
that the circuit will
When,
commence.
when
from today.
his matter is posted, why?
Your lordship, actually, he has serious medical problems that has erupted in the throat.
What
He's a cancer patient, your lordship.
Where he has gone?
Calcutta, your lordship. He's not over here.
There's a gum cancer and got it operated.
Has he recovered?
He has recovered, but he was doing practice. Maybe he said something erupted. Recently, there is some development. I was not aware of the recent development.
We are making it not this week, but ensure that if something happens.
Obliged.
Next. No order is recorded. Not this. Week.
Item number 41, my lord, victim could not be served, my lord. May I kindly allow us to serve the again.
Janardhan Periwal, who is he?
I'm with Juni. I'm with Juni.
So,
You are seeking 1 day accommodation.
who you are the advocate record?
Yes, my lord.
So why you are not? Why you are pushing your junior?
My lord, I need certain documents, my lord. that
So
have
whatever,
come
then
to
you
me,
should
my lord.
have come and then don't use the juniors for this.
My sincere apology. Can you give me a day's accommodation, my lord? I shall come back tomorrow.
No, definitely not. You have to do it.
My lord, my clients are to give me some documents, my lord. Kindly permits me a day's accommodation.
What are the document? You
Tomorrow.
are in custody from, how you will give you a
Tomorrow, my
document?
lord. Kindly gives me a day's accommodation. my
Yeah,
lord.
he is in custody. How can he give you a document?
There are 2, my lord. One died, one survived. Include witness, recovery, fingerprint.
My lord, kindly gives me a day's accommodation. I shall do it tomorrow. Positive.
Tomorrow. Oh.
After the studio,
Lordship, item number 43, I am paying for next circuit, Lordship.
That's why, my lord, on Friday.
You are competent, you do it.
My lord, then kindly fix the matter 46, my lord.
Yes. You are the advocate and record, you should do it.
My lord, may I start, my lord?
Yes.
My lord, allegation under section 103 and 238 of Bharatiya Nagaric
We are hearing
Samhita,
45, we are hearing 45.
45, my lord,
Yes.
2023. My lord, the present petitioner is the uncle of the victim girl. My lord, he has gone with his brother for lodging My lord,
May grant me.
my lord, Mr. Bhaskar Rai Mahasaya is for
Whatever.
treatment.
Let us see.
My lord, I did watch it and not today, my lord. Kindly, my lord.
What is this? She knows the fate of it, that's why.
No, my lord. My lord, he is a senior in this matter. For his treatment, my
You are a advocate in the court, no? Is your obligation to do it first.
kindly then not today. My lord, kindly, my lord. I am praying by folding hand, my lord. Kindly, my lord.
There is no newspaper publication. Modern.
Yes,
Sir.
there is
He was a-
extra marital
he is-
relationship
Yes, he was
between the
extra marital.
Are impugned. That in internal page number 19.
দেবেন যে প্রত্যেকটাতেই থাকা উচিত।
There is a certified copy, so non-designated.
49.
My lord, for item number 49, I'm getting.
My lord, I'm appearing for the petitioner, my lord.
Sir, we can't, what is this?
My lord, it's amendment to.
What
306, my lord.
of,
306 of IPC.
No, no, my lord, it's
This is the
amendment to
victim.
suicide, my lord.
the victim?
Victim, my lord, a lady, my lord.
How can it be? Sir, we will do not permit
My lord,
any
kindly
case
takes it up next week.
concerning the woman or a child to be conducted
My lord,
on,
my lord,
sorry.
my lord, kindly fix it up next week, my lord. My lord,
Sorry.
kindly.
We can't, you'll have to appear tomorrow.
My lord, I'm at Calcutta, my lord, that's the reason.
So
My lord.
whatever, there is a very, very good communication between.
Yes, my lord, yes, my lord.
and the Jalpaiguri. So
My
come
lord,
you
tomorrow, my lord, I'm under extreme difficulty tomorrow, my lord.
tomorrow, all right?
My lord, kindly Monday, my lord, kindly,
Sorry, day after tomorrow.
my lord.